for attending today. I'm going to say in advance, thanks for your time and attention. It was a difficult determination to try to figure out what we were going to talk about for employment, because it is bouncing all over the place. If you do any employment work at all, if you touch any of the handbook provisions, work rules, safety policies, wage and hour, discrimination claims. I mean, the federal government, like they got shot with steroids or something and some kind of amphetamines because they are on fire. So we're just going to touch on 3 areas. The primary time I'm going to talk about this morning are non-compete agreements, just because that's been very interesting on what the courts have done. Then we will touch about wage and hour in a recent court case that just changed everything again. And then for the first time in 25 years, the EEOC issued guidelines on interpretation of discrimination and harassment. I think I went and took a look. If you count the footnotes and commentary, it's nearly 1,000 pages. So, you know, you could spend another 25 years trying to digest that. Well, here we go. Buckle your seatbelts. Non-compete agreements. Very simply, it's a contract. It's been used for many, many, many years. It's a contract between the employer and the employee to not compete. Now, if you think about it, it's flexible, okay? Like some non-compete agreements make total sense to have the former employee not directly compete with your business because you maybe spent 4 or 5 years investing all sorts of training and money and time into that individual, and then they have access to confidential information, client lists, etc. If somebody comes to your employment and they are already trained, they already have some clients or whatnot, and maybe they're in sales, so they would have a client list, that's a different scenario. So what you're going to see is the courts have struggled with trying to tailor the non-compete agreements in time, in geographic scope. And then there's another thing that Rob Solt told me about this morning, which I hopefully won't forget, I'll touch base on, and it's a way to effectuate a non-compete agreement without saying non-compete agreement. Basically, you get a settlement agreement or a separation agreement, and you tell them you can't have any earnings for a period of time. So they're not going to work, but you're not saying don't compete. So that's really creative. This non-compete agreement document or tool goes back to World War II eras, 1942. And it is a legitimate way to protect your client lists, trade secrets, pricing, confidential information. And as we move more and more into the information age, client relationships. To be enforceable, however, the courts have said they have to be tailored narrowly to protect your legitimate business interests, but not be unduly burdensome on the employee. So, you know, we don't want the employee to be unable to go out and make money and support their family. So it's a balancing test, which I will talk about. And there's all this kind of amorphous or really undefinable thing called public interest. And we'll talk about that in a little bit. Ohio has been very supportive of non-compete agreements. They believe that that is a valid way to restrict competition and protect an employer's legitimate business interests. Like I said, this goes all the way back to 1942. Well, we've been using non-compete agreements now for, let me get somebody younger. Number 4, how many years is it? 80?
I don't do math.
Okay. Yeah. Okay. But this is an interesting case. Raimondi versus Canvalera. You wouldn't think that two guys with names like this would be veterinarians, but that's what they were. And the Raimondi had a veterinary practice. So he had a pretty successful practice, and he was expanding in Defiance. So right down the road, right out the new 24 superhighway, Route 24. And the Van Clara was a newer guy. So Raimondi, I think I'm probably getting that right, started his veterinary practice in 1961. In 1972, Van Clara came on board, and they had a good practice going, but apparently they didn't get along very well, because Van Clara started in January of 1972, and his last day worked was November 24th, 1972. As part of the employment agreement, there was a very clear and distinct non-compete agreement. The non-compete agreement said, for a period of 3 years, Mr. Canvalera, I want to say Van Clara, but it's Canvalera, you cannot directly compete with me in the veterinary practice for 3 years within a 30-mile radius. So what does Canvalera do? He submits his resignation according to this employment agreement that they had both signed, and immediately went out and started having a veterinary practice in Defiance, basically less than 5 miles from the office. Mr. or Dr., I guess it is, Raimondi filed an action in the local court there in Defiance, and we've recently done a couple of non-compete agreements in our office. What you do is you file a case in court and you request an injunction to effectuate the terms of your non-compete agreement. So all Dr. Raimondi was saying was, you signed this agreement, Canvalera, and you shouldn't be practicing veterinary medicine less than 5 miles from our office. You knew what you were getting into, you're well educated, you signed this of your own free will in accord. What the court did was they went through this almost torturous, multi-page reasoning to come up with a very simple test. There are 3 parts to it. The main thing that I'm going to hammer away on throughout this presentation on non-compete agreements is it has to be reasonable in time and geographic scope. So the court basically said, and they did something, they call it a pencil test. There are all kinds of colors, and I'm not making this up, I am colorblind, so it doesn't make, I don't really care. It's a red pencil test, it's a blue pencil test, but it's a pencil that they go through and they say, part of this contract looks good to us, but the other part maybe it's too egregious, it's too much in favor of the employer. So what the courts did, it worked its way up to the Ohio Supreme Court, and the court basically said 3 years is reasonable, but we're going to cut it down to 18 miles. So that's kind of the way the courts are looking at these non-compete agreements. They are empowered to modify the agreements, basically what I just said. So what's the takeaway thus far? Make sure that you use appropriate language if you're going to use non-compete agreements. And keep this in mind as I'm talking. What is it you're trying to protect? Do you really want to keep somebody from working? Or do you want to protect your trade secrets and your confidential information? When I say trade secrets, you better treat that information like you would something that's secret. Okay? That means only certain people have access to it, and it's not generally known to the public. Non-compete agreements are under attack, which is why this is part of our presentation this morning. Just about a couple of years ago, the Federal Trade Commission, there'll be a case from the Federal Trade Commission, and the National Labor Relations Board signed a memoranda of agreement that they didn't like non-compete agreements. So they were going after non-compete agreements, and they were going to attack any employer who had non-compete agreements that were overly broad. So you can see on this slide that both the National Labor Relations Board and the Federal Trade Commission have issues with non-compete agreements. But they're coming at it from different angles. The Federal Trade Commission says, hey, this is not good for businesses. The non-compete agreements push down on creativity and competition. So the Federal Trade Commission believed that it was within their authority, their legal authority, to address non-compete agreements and abolish them, which is what they did. The Federal Trade Commission, their Enabling Act. So if I got to where I was teaching 18 to 25-year-old people, and I got like more diarrhea of the mouth. So you have to kind of, I apologize if I'm babbling too long on certain topics. But the Federal Trade Commission, part of their Enabling Act, and that is what Congress says you can do. We're going to create the Federal Trade Commission, and here's why, and here's what you can do. What the courts are going to say, which I'll talk here in a minute, is, hey, you went beyond what Congress said you can do when you started saying non-compete agreements are null and void from the beginning. So you can see it started to heat up. You'll see when the National Labor Relations Board, they started in 2023. But this year, April 23rd, 2024, the Federal Trade Commission announced a rule publicly, and that was the effective date of that rule. It didn't get put into the Federal Register until May 7th of 2024, but I want you to remember April 23rd, 2004. It was to become effective September 4th, 2024. It was very wild when I first read this. I couldn't believe the Federal Trade Commission was basically doing what they said they were going to do. Not only did they make non-compete agreements null and void, you as the employer had to notify all your employees, interns, volunteers, and get this, independent contractors, sole proprietors, that these non-compete agreements were no good. They have no validity. And so there you go. Except for certain executives, and if you're buying or selling a company, non-compete agreements would be valid. Within an hour, and I didn't look exactly, was it 50 minutes, 55 minutes, I don't know, but it was within an hour of the Federal Trade Commission's publication of their rule against non-compete agreements, Ryan LLC filed a lawsuit against it. Ryan LLC is a global tax company, so the non-compete agreements had a lot to do with their clients, and plus, to be honest with you, and Ryan LLC is very open about this, they thought it was a good marketing tool. So they took the lead, they filed a lawsuit against this rule from the Federal Trade Commission, and then everybody joined in. U.S. Chamber of Commerce, all kinds of different associations joined in and argued against the ban on non-compete agreements. On August 20th, I think I've got this, yes, August 20th, the Texas court set aside the Federal Trade Commission's rule. They did it on a couple of bases, but basically what they said was, you went beyond your authority. You're an administrative agency. You're here to protect fair trade and competition. You're not here to abolish a rule. That's a court's job. not an administrative agency. So the result of that is the rule is what we call stayed. It doesn't go anywhere, it just sits there. All of your non-compete agreements are still valid now from a federal perspective. Don't forget, state laws might be against non-compete agreements. Big cities, New York City, Chicago might be against it. And everything's against employers out in California. So basically, non-compete agreements are good. This case is under appeal now. The Federal Trade Commission filed an appeal in federal court. It's going to be a little while before that is adjudicated fully. You might wonder why in the world the National Labor Relations Board got into this whole non-compete agreement issue. The National Labor Relations Board not only is involved with unions, labor unions, but any private employer that's non-unionized as well, on the issue of wages, hours, and terms and conditions of employment, what we call WHAT. So I like acronyms, EEOC, NLRB, you name it, I keep going, try to cover every letter in the alphabet. But WHAT, wages, hours, terms and conditions of employment. The theory is, according to the National Labor Relations Board, is that Section 7 of the National Labor Relations Act protects employees in their ability to discuss wages, hours, and terms and conditions of employment. That very well might be going to work at other places, to better my life, to get more money, maybe do something I want to do, rather than doing something that I've always had to do. So there's the theory that non-compete agreements interfere with that discussion of wages, hours, and terms and conditions of employment under Section 7. Got it so far? Everybody following? Okay. The National Labor Relations jumped in. General Counsel issued a memorandum against overly broad. They didn't define what overly broad means. They just said overly broad non-compete agreements are invalid. Then there was a case. An administrative law judge for the National Labor Relations Board issued a decision against work rules that included non-compete agreements. The company is Maury Inc., and it's not a big company. I was kind of surprised why the National Labor Relations Board took such interest in this case. This little air conditioning, heat and air conditioning company. But they did have in their handbook a statement of union-free workplace. So maybe that caught the attention of the National Labor Relations Board in Indiana. That's where the case came out of. And they just determined that this handbook rule provisions against non-competition and confidentiality, the language in there is invalid. So they invalidated that. The couple of employees who were terminated had to be reinstated, and they had to take that language out of the handbook. So, takeaways: Federal Trade Commission, National Labor Relations Board, probably just about any other federal agency would be against non-compete agreements. You might remember I said, what is it you're really trying to protect? You're trying to protect confidentiality of your pricing, your client list, how you do business, and trade secrets. So that's what you're trying to protect. What we've gone to more in our office is crafting confidentiality agreements and trade secret agreements. And so you can get the same thing and not have a non-compete agreement. But they're still valid right now. So that's the first topic. How am I doing on time? 10, all right. We can get into the weeds now, Mr. Soul. We are going to touch base on wage and hour issues. So, how many here know that the Wage and Hour Division has made it requirement, it's made a requirement that you have to have certain increased pay levels in order to enjoy the exemption for executive, administrative, and professional employees. People know that, right? Have you already bumped up the first one? Anybody had to deal with that from July? Okay. So this really touches on restaurants and retail industries more than other kinds of industries. But here's the bottom line. Under the federal law that came into effect late in the Depression era, if employees work more than 40 hours in a work week, you have to pay them time and a half, called overtime. The work week can be crafted however you want. So don't think it has to be Sunday through Saturday. You can make it Monday through Sunday. We've seen some companies do Wednesday through Tuesday. It doesn't matter. It has to be a full work week. If your employees work over 40 hours during that work week, by federal law, you're required to pay them time and a half on any hour that they work over 40 hours. And by the way, this isn't in my PowerPoint slides, but this is a golden nugget for you. If you have bonuses that you're giving out, you have to include that bonus in the calculation of the hourly rate, upon which you then do the time and a half calculation. Unfortunately, we've had a couple of clients end up with class action wage and hour lawsuits because they were doing the right thing, paying bonuses for people who worked hard, and they didn't include it in the calculation of the overtime, the basis for the overtime. Cost a lot of money for them. So, there you go, back to this. The Fair Labor Standards Act did just what I said. There are the executive, administrative, and professional exemptions. You have to have these three tests. So job duties are the big one. There's a court case that talks about job duties. I'll touch on that in a second. Then there's the salary test. And this is what caught the court's attention. So in July, the salary went from what had been $844. Now I've been $36,000. I'm trying to get the exact numbers, and to bump up to $43,000, and then it was going to go even further, $56,000, I think it is, effective in January. That's all coming from the Wage and Hour Division. Let me see, there we go. There was a court case that popped up. It's happening all over the place. The federal court in Texas, which is the same place that the case that I just talked about in non-compete agreements, the federal court down in Texas said, no, pretty much same reasoning. This is way beyond what you're supposed to be doing as an administrative agency. You're supposed to be looking at job duties. If you're going to talk about this part of the exemption for overtime, you should take a look at job duties. That's what your authority is per Congress. Your authority is not to set wages that constitute an exemption. And it was a significant increase that would have affected over a third of the workforce, this increase in the salary test. So recently then, and when I say recently, I mean November 15th, Federal District Court vacated the salary threshold. So if you're doing this, you're increasing wages so that you maintain exemptions for some of your employees. You don't have to do it any longer, according to this. But this is going to be appealed. So there was a case that came out November 15, 2024, and the court said Congress intended the Department of Labor to define the duties of these exempt positions, not the dollars paid to them. Of course, now we have a change in administration, so I don't know, this may just be a dead issue. But we wanted you to be aware of it because it does affect money that you're paying to employees, maybe. Any questions on that? Well, what are you going to do if you've already increased wages to these employees so that you maintain the exemption from overtime? Are you going to roll it back? Pardon? You know, you can't do it retroactively. That would be a major problem. That's something that we call the Full Employment Lawyer Act. So if you roll it back and go retroactive, you're going to get in all kinds of trouble. Then you got the morale issue if you decrease the wages from now going forward. So my recommendation from a business perspective is I would just keep it where it's at and avoid the increase in January, if you're in this position that we're talking about. All right. Unfortunately, I only have a short period of time because this topic, the EEOC regulations, could go on for 3 hours at least. And it would not be boring. This is a hot topic area. Like I said, this is the first update in 25 years. The EEOC, which stands for the Equal Employment Opportunity Commission, has jurisdiction over workplace discrimination and harassment. It's, you may have heard it over the years, Title VII of the 1964 Civil Rights Act, and different classes or characteristics of your employees are protected under the law. This is so huge, and all I wanted to do is just make you aware of it, that there are fact sheets on the website, summary of some of the key points in this law, and then you get the typical frequently asked questions. And there are about 75 frequently asked questions on the website. There is guidance on race, sexual orientation. I just picked a few of them. The EEOC's stance, for example, on race, how people wear their hair. That is protected, and they explicitly state that under the new guidelines. Sexual orientation is also a topic that they explore in depth on the guidelines. So that's pretty much it for my presentation here today. I could go on, but I just really wanted to make you aware, not only the EEOC, but there's just non-stop activity from the federal government relative to how you do things in the workplace. And it seems like every time there's an issue that Congress wants to resolve, they place the burden on the employer. So you're becoming burdened more and more with how you interact with employees in the workplace, and it's becoming difficult. I've been doing this for a long time. It's becoming difficult, I think, to get your product out. So Mark's going to talk more about some of the other issues about disability and leave law, which kind of flows in with the EEOC guidelines. But if you don't have any questions, I'll just go ahead and call it a day. All right? Thank you.